If you have decided to move forward through the mediation process, the first choice to make is, are you doing that with you and your spouse and the mediator, 3 people in the room? Or are you doing that with you, your lawyer, your spouse, their lawyer, and the mediator, 5 people in the room? That's step 1. The choice of who is the mediator is going to be decided by the people in the room. So if it's you and your spouse, then you two are going to decide who is the right fit to act as your mediator. Some considerations would be whether or not you both feel comfortable with that mediator, whether or not that mediator possesses the background that's needed to decide your family matters, whether or not you both trust that mediator and trust the information they're going to be telling you and the advice you may be asking of them. If you decide to move forward in mediation, each represented by counsel, 5 people in the room, the decision of who is going to be the mediator is still going to take in all those factors: trust, reliability. But in the 5-person scenario, your lawyers are going to also be choosing that mediator based upon who they think is going to best facilitate their desired outcome based on your requests. So when you have 5 people in the room, you are going to be a part of choosing the mediator, but you may not be doing all of the initial interviews. Whereas if you have 3 people in the room, you and your spouse will be doing all of the initial interviews. It's important to note that if you are not using lawyers, if you're doing 3 people in the room, both you and your spouse must engage in that initial conversation with the mediator. There is no calling ahead and getting your side out before the other side calls. You both have to talk together. And if you don't, then what you've done is you've effectively eliminated that person from helping you. At my office, I require both people to sit in the room with me so I can see them live and in person if we are doing a 3-person mediation. This way, you're both protected and you're both able to analyze the information, both receiving it at the same time. In a 3-person mediation setting, when you're determining the right mediator, you want to look at their background. If you have a scenario where your spouse is suffering from some medical issues, you may want to work with a mediator who has either some social background, some medical background, who knows someone who has some medical background, or has a way of gathering information so that the needs can be met. If your spouse is paid in part through stock, you want to work with someone who understands stock options, who understands investment schedules. So you want to work with someone who has an understanding of the compensation packages. If you are someone who is going back to school or wanting to relocate, or pick a myriad of other nuances that are unique to you, or at least that you feel are unique to you, that's the questioning you want to do. You want to ask what they know about relocation. You want to ask what they know about high net worth. You want to ask what they know about division of substantial retirement accounts. Those are the key questions, because if the answers are that they don't know, then you want to ensure that they're going to find out and they're not going to rely on you to tell them. And if the answer is that they know, but it's something different than what you understand it to be, then you begin to challenge that conversation. Again, just to make sure you're working with someone who you feel most comfortable to guide you. When you choose the route of mediation, you may participate in 1 session or 7 sessions. Mediation and the timing of mediation is completely fact specific. People have come to me, they've resolved everything and they're down to 2 issues. I don't need to sit with them that long. I can just help them with the 2 issues and then we move on. I've also had people come to me and we've taken 5 or 6 sessions. It wasn't adversarial, it was not fighting, but they didn't have enough information to make a decision. When you mediate, you have to make an intelligent decision. And by intelligent, I mean you have to know. You have to know what you're getting. You have to know how you're getting it. You have to know when you're getting it. To make an intelligent decision, sometimes we need to get more information. If you have an investment account, we need to know, where are the stocks invested? What's the cost basis? We may not know that in the session that we're in. We may have to come back later to figure that one out. Sessions should always be non-confrontational. That does not mean that everyone's getting along. It means that we're being respectful. Sessions should always have forward productive movement. Again, it doesn't mean we've made an agreement, but we know the next step to get towards the agreement. And we should see progress in every session. If you've come to multiple sessions and you're just stalling, then the mediation is not the right place. It has now failed. It's time to move on to the next stage. You will know if you are in a good mediation if you're taking these steps. And that's not about the mediator, it's about the mediation. You will know if you're in a bad mediation because you've stalled. If you're working with a lawyer at these mediations, the lawyer will say to you, it's time to stop mediating. We need to go to the next step. We've stalled. But that doesn't mean you can't go back. Once you stall, you can take the next level that you have to take, but you can always go back to mediation. That's the nice thing about mediation. You can go in and out of it as needed. Mediation is something to be embraced, but it is not something to be the end-all be-all. It is not a pass-fail. It's something that is fluid. When you participate in mediation, the goal and the outcome is to have an agreement as to the division of assets, the determination of support, and the decisions regarding custody and parenting time. You will not walk out of a mediation divorced. You will not walk out of a mediation with a court case to get divorced. When the mediation is complete, you will then have to go to court in order to accomplish the final judgment, because only a judge in the state can issue a divorce decree. Mediation has a lot of twists and turns. Please give us a call at Jersey Coast Family Law to help you navigate the area of mediated resolution.